Civil Rights Part 2. In this section, we're going to talk about Section 1 of the 14th Amendment. As written, it stated, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Let's talk about the Equal Protection Clause. This is the last part of this section, which says, nor deny to any person within its jurisdiction the equal protection of the laws. It's a very short clause, and yet we've used it for so much over history in terms of civil rights. So let's go through a couple of different cases which show us the different uses that have been put in place for this particular clause. The purpose behind this clause was to prohibit unreasonable discrimination. So if a state wanted to treat people differently, it better have a really good reason for that difference. Remember, we're dealing with actions of the state. And so it's the state and state actors which are not allowed to do things which would unreasonably discriminate against people. So when we're looking at these cases and we're looking at the actions that are coming forward, remember that these are all state actors or funded by the state in some way. The government may not enact regulations that treat certain classes of people differently unless the government meets a particular burden. So what is this burden? Well, the burden actually is different depending on who you are and what you're being discriminated against, on what basis you're being discriminated against. So there are three different standards of review which the court has set up. Remember, we have a very short clause which was enacted by the legislature into the Constitution and ratified by the states, and then from that small clause, the courts were left up to actually interpret what this means. And so let's look at how the courts have done this. The courts have established three standards of review. In other words, depending on what you're being discriminated against for, a different rule is going to come into place on whether or not that discrimination is okay or whether it's not okay. So the three standards of review, very important to know. The first is called strict scrutiny. Strict scrutiny says, okay, the law which was put in place by the state can be upheld, so it's not going to be struck down, if it is necessary, the least restrictive alternative, to achieve a compelling governmental purpose. We use this with suspect classes and with fundamental rights, which we'll talk about in a minute. So that's the highest level of scrutiny. It's got to be necessary to achieve a compelling purpose. Second level is called intermediate scrutiny. That's when the law is going to be upheld if it is substantially related to an important government purpose. So you can see how this is a little bit lower. Instead of being necessary, the law only has to be substantially related. And instead of having to achieve a compelling purpose, it really only has to achieve an important government purpose. Lastly, we have rational basis review. Rational basis review says the law will be upheld if it is rationally related to a legitimate government purpose. And so again, really lowering the bar of what has to be proven, again, from even intermediate scrutiny. In other words, the actual purpose doesn't have to be legitimate as long as the court can ascertain some sort of rational, conceivable purpose. So who gets to use what type of scrutiny? Classification is one big thing you want to look at. To prove discriminatory classification, there has to be an intent on the part of the government to discriminate. Now, it can be discrimination on its face, it can be discriminatory application of that law, or it could have a discriminatory motive or discriminatory effect. Suspect classes. The court has found race, national origin, and alienage to be suspect classes. That means that they're going to require strict scrutiny. Quasi-suspect classes require only intermediate scrutiny, and this is gender and illegitimacy. Everything else only gets rational basis review because they are non-suspect classes. So wealth, age, marital status, pretty much anything which is not those five who are listed is just going to get rational basis review as its standard of review when you're looking at whether or not that law should be upheld or whether it should be struck down. So let's look particularly at racial discrimination. This is one of our suspect classes, and so it's going to receive strict scrutiny by the courts. The law is going to be upheld if it is necessary to achieve a compelling purpose. Race always receives the highest levels of scrutiny. So let's see what the court has done with racial discrimination cases. We want to look here at 5 different cases over the history who have applied the Equal Protection Clause to race discrimination. Now, these are old cases. Most of them have been overturned, and so it's important to know where they are in the places of history. But what I want you to take away from this is not only how the court chose to apply strict scrutiny under the Equal Protection Clause to the racial discrimination, but also that no one holds a monopoly on discrimination. There are cases in the United States history, and though we've picked out 5, really against every race that has inhabited this country, which is sad but true. And so I want you to take away that really we have a colorful history of how we have discriminated against folks at the state level and what we've been doing to combat that. First case I want you to know about is Plessy versus Ferguson, very familiar, very famous case from 1896. And this was a case in which we had a state law, so it always begins with some sort of state law which is discriminatory, right? So this was a Louisiana law. And the Louisiana law said that there have to be separate railroad cars, that was the way people traveled back then, for white people and for black people. They couldn't be in the same car. And so Homer Plessy, who was the plaintiff in this case, argued that when you segregate people like this, it imposes a badge of inferiority. So it's inferior to have to ride in, say, the black car versus the white car. Now remember, we had the 13th, 14th, and 15th Amendments come out that said you can't hold people in slavery, you've got to allow them to vote, at least black males to vote, and that you need to protect them under the laws. But there were a lot of these black codes that were coming up which were saying, well, let's find ways so that we can continue to act the way that we did, the states meaning the way that they did, while still adhering to this federal law. So the court looked at this, and they actually disagreed with Homer Plessy. They said, you know, it's not inferior. It's fine as long as you have 2 separate things that are equal, because you are still equally protected under the laws, but you don't there's nothing that says you have to actually mix. And so the court disagreed with an 8-to-1 majority, and it said that racial segregation in public facilities, if they were allegedly equal in quality, actually didn't violate the Equal Protection Clause. This is where we get the famous separate but equal ruling. In the 1930s and 40s, we had the NAACP bring up some impact litigation because as they were seeing, separate facilities were hardly ever equal. You had separate facilities, but there was a far superior quality of certain facilities versus other facilities which were required to be separate. And so the NAACP reasoned that the states would find it too expensive to maintain separate but truly equal public schools, and so this was the thing that they would go after. They said, okay, fine. How about this? You don't want to mix white and black students. However, what if a black student wanted to go to graduate school? And the graduate schools that the white students are going to have wonderful labs set up and fantastic professors and all sorts of resources. Does that mean that you are going to build a separate but equal facility for the black student who wants to enter that profession or that particular graduate school? And so the court actually ordered the states to admit black students to all white graduate schools when black facilities were unequal or they were non-existent. Because as the NAACP had postured, there weren't going to be any facilities out there which would be built specifically for black students to have a separate but equal graduate program that they were looking for. So the court said, all right, fine, you must admit black students to the all-white graduate schools. So this is, the first step of kind of cutting into that separate but equal argument. but only when the black facilities are unequal or if they're non-existent. In 1944, we kind of had a switching of gears. Not that anything went away with Plessy versus Ferguson, that was still going on, but we had World War II. And World War II changed the animus of the country to really looking at what was going on with Japanese Americans at the time. And so we had FDR, Franklin Roosevelt, who was the president at the time, and he issued an executive order, number 9066. And what this did was this interned 120,000 Japanese Americans in concentration camps. Basically, it said, if you're Japanese American, we can round you up, tag you, and send you to a concentration camp. And this is what happened in 1944. Now, 2/3 of these folks were natural-born U.S. citizens. In other words, very many of them had never even been to Japan, ever. But the fact that they were Japanese and they were easy to pick out because they quote-unquote looked Japanese meant that they could be rounded up and sent to the concentration camp. So Fred Korematsu and Gordon Hirabayashi were two plaintiffs in this case who brought this case. They were U.S. citizens, and so they said, we can bring this case to say that this is discrimination against us. And the court used the Equal Protection Clause to look at this and say, okay, we have strict scrutiny. Is this something which is necessary to achieve a compelling government purpose? And the court upheld the law, saying that the military orders would be upheld because the actions were not based on racial animosity. They were based on the fact that Japan was an enemy. So what they said is, this isn't racism, this has to do with enemies in war. So that's kind of how they squiggled out of the strict scrutiny argument here. However, it's interesting to note the German and Italian Americans, also quote-unquote enemies of World War II at the time, weren't treated similarly, most likely because they were much more difficult to pick out in a crowd than the Japanese were. But we had a lot of difficulty in this particular case. We had the Solicitor General, who of course is the big lawyer for the government, who knowingly misinformed the court that the U.S. military had evidence of disloyalty of Japanese Americans. And so with that evidence and with other things that were there, they actually upheld this unjust executive order. 1954, we get Brown versus the Board of Education of Topeka, Kansas. You might have heard of this before. This is the NAACP again, continuing to do its work. They had won a major victory in getting the graduate schools to be integrated, at least some graduate schools to be integrated. And so they wanted to turn their attention to segregation in elementary and secondary schools. So they said, okay, well, same thing here. We have separate but unequal facilities, and so this is a violation of the Equal Protection Clause. And the court actually ruled in this case that separate educational facilities are inherently unequal. In other words, separate is not equal. This is where we had Plessy versus Ferguson overturned. In other words, remember how I said that you had that case, but then it really doesn't stand anymore, and that's because of Brown versus the Board of Education. This overturned the earlier court's judgment, and the court ordered school districts to begin desegregation with all deliberate speed. Now, what does with all deliberate speed mean? That's a good question. If you don't know what it means, then you're in the right company, because nobody knew what that meant. And the court didn't say what that meant. And so the state said, all right, fine. We don't necessarily want to follow this in some cases, so we're working on it with all deliberate speed. And of course, with all deliberate speed meant to them really not at all. In fact, you had 101 members of Congress who signed a Southern Manifesto in 1956 opposing the ruling altogether. And Eisenhower President Eisenhower at the time, had to actually order the 101st Airborne Division to accompany the Little Rock Nine to actually enter. The Little Rock Nine, if you don't know about them, great to read about, very important history to know about these 9 black students who were going to be integrated into the Little Rock school districts in a white neighborhood, in a white school district. And so Eisenhower actually had to order airborne, military officials, soldiers, to go and accompany them to make sure they were safe to attend school there. And so with these particular problems, with all deliberate speed being a huge problem, because really it wasn't creating any differences in the southern states, the case came back to court in 1969. Well, not this particular case. Other cases came to court in 1969, where the court said, all right, with all deliberate speeds not working, you've already been told you must desegregate, and so you must desegregate, quote unquote, at once. And of course, 1969, we're really in the middle of what we know as the modern day civil rights movement. We had the court striking down segregation in transportation, in prisons, in public parks. A Virginia law which declared that interracial marriages was illegal was struck down as unconstitutional. And we had a lot of good things coming out of the courts at the time, but the problem that we had was enforcement, was that you had states and you had certain individuals who were working for the states or working for law enforcement or working for as different state actors who were saying, okay, that's great, that's what the court said, but you're not going to change the way that I interact in my community. And this is really why we had the big push of the 60s civil rights movement. Important legislation. So we're kind of flipping back for a second to the legislative branch, out of the judiciary, to the Civil Rights Act of 1964. We had this act, this law that was passed to prohibit discrimination in employment based on race, based on religion, and based on gender. We had the problem that there was past discrimination, and we had to really deal with the effects of past discrimination, and so that law came up. Of course, again, same thing as we had with the courts. We had a law in place, but still a lot of problem with implementation, and we had the March on Selma, Alabama, led by Dr. Martin Luther King Jr., right around this time, and actually right after his march, we got the Voting Rights Act of 1965, again enacted by Congress, and what this did is it prohibited literacy tests, allowed federal officials to supervise voter registration, outlawed delusion of minority voter strength in drawing districts, and really gave some teeth to that 15th Amendment that says that black folks could vote, because we really wanted to combat the black codes that were going on at the time, and particularly around voting. And so that's what the Voting Rights Act of 1965 did, because we also had a lot of different things. This was really the beginning of other things which would go on to try to change the way that people acted in their communities. You still had, for example, after this, a lot of practices which were very discriminatory. For example, you'd say, all right, the voting official to say, okay, fine, well, then black people, you can vote at this polling place, and they would give them directions to a wrong polling place. Or they would try to get there and they'd say the roads were closed. Or they would wait in line for forever just to have a couple of people who were against black voting sitting at the door with shotguns. And so there were still a lot of practices going on, but this was a major victory in terms of national legislation, which was going to help move along the civil rights movement. And this was great because we were actually working through the system. We had all three branches of government working together to actually moving things along in terms of the civil rights movement. Of course, you had your grassroots on the ground. There was fantastic mobilization done by a lot of really great civil rights activists at the time. But in terms of governmental action, we had Presidents Kennedy and Johnson introducing bills which were going to assist us. We had Congress passing laws which was going to assist us. And then the courts would then uphold the laws and back them up with favorable decisions instead of striking them down. And so this really helped, particularly in two areas, in school participation and voter registration, where we really saw an increase in participation on both ends. You can see the difference in school participation between 1968 and 1972. Not that many years apart, but we're jumping 18% to 46%. Similarly, with voter registration, 5 years apart, we have 36% to 65%. So really increasing, working through the system, increasing the efficacy of these particular laws that were put into place. In 1978, we had the Regents of University of California versus Bach. This flipped things around a little bit differently. We had a lot of affirmative action laws which were put into place between this time in the late 60s, early 70s. And so Bach was a white man who was denied acceptance to a college of his choice allegedly due to a quota system. What the quota system said was, well, because of affirmative action, because we're trying to deal with the past discrimination which has befallen black people in our country, and particularly in college admissions, we are going to set aside a certain number of seats in the incoming class for African Americans. And this was called a quota. And so Bach's argument was that if he would have been black, he would have been admitted. But because they filled up the number of seats that they had for white men, and the remainder of seats were only for black men, he was being denied acceptance based on his race, based on the fact that he was white. So the court looked at this, again, strict scrutiny, right? So it's race, so are we looking at a law which is necessary, or in this case, not a law, but a college system. Remember, the college is an actor of the state, right? It's funded by the state, run by the state. So is this action necessary for a compelling purpose? And so the court ruled here that strict racial quotas like this, that said certain numbers, actually violate the Equal Protection Clause. They are not necessary, in other words, to achieve a compelling governmental purpose. Now, they did say that they allowed universities to use race as one of several factors in admissions, but they said that this racial quota thing had to be struck down. And their rationale for saying, but we can still look at race, was, and this was Justice Blackmun at the time, in order to get beyond racism, we must first take account of race. We've got to take a look at what's going on, can't just not look at anything at all, or else we're not going to be able to assess what's going on. Again, this is 1978. In the 1990s, we had appellate courts looking at this saying, okay, this decision to strike down the quota system, we got it. However, allowing universities to use race in admission, I think we've kind of outgrown that. And so in the 1990s, the appellate courts ruled that race can't be used at all. You cannot look at race to be considered at all for decisions of admission to state universities. So you can ask questions about it, but you cannot decide whether or not to admit somebody to a state university based on whether or not they're part of a certain racial group. 1989, we had Richman versus Croson. In this case, the court struck down a city council policy. So again, not exactly acting the state itself, but a state actor in that it's a government actor. So this city council's policy said that they are going to award municipal contracts, so contracts that the city council engages in, to minority-owned businesses. And the court said that programs at the state and local level have to provide a compelling interest. Again, we're still at strict scrutiny because it has to do with race. And if you're going to discriminate against white men by not allowing them to receive or be awarded these municipal contracts, then you've got to pass that strict scrutiny test. In this particular case, the city did not demonstrate a need for remedial action and that other non-discriminatory remedies would be insufficient. Remember, you have to look at strict scrutiny again. It has to be necessary, right? And then you have to look at for a compelling governmental interest. This city didn't prove it. The court didn't say other cities could not. Other cities who could say that they did demonstrate a need for remedial action, we had to give these awards to minority-owned businesses because we have whatever particular argument that they had that it was compelling, could meet that test. But in this particular instance, the city did not demonstrate this need, and so that particular practice, that policy, was struck down. Now, before we leave this area of extraordinarily quick and shallow discussion of racial discrimination in constitutional law, we want to talk a little bit about discrimination against aliens and non-citizens. Now, two cases I just want to mention. 1886, so quite a while ago, we had Yickwo versus Hopkins, and this was, again, a Equal Protection Clause under the 14th Amendment case, but we were looking instead at non-citizens, and whether or not non-citizens are actually protected under the 14th Amendment. So, the particular clause that we were looking at here with equal protection was this part that says, nor deny to any person within its jurisdiction the equal protection of the laws. So in this particular case, you had the argument that even if these folks are non-citizens, and so would not be able to say maybe bring a case of their own for racial discrimination, they are within the jurisdiction of the state who's actually discriminating against them, and so that would give them grounds to be protected under the 14th Amendment. So from this case, we got that states are prohibited from denying most benefits to non-citizens. That's why you have a lot of non-citizen involvement in certain governmental programs. Now, there are, of course, exceptions to this, voting, jury service, for example, things which require citizenship, but it really began that argument that if you are subject to the laws and jurisdiction of the particular of that particular jurisdiction, then you are going to be equally protected under the laws. 1982, we had Plyler versus Doe, and this case struck down a Texas law. The Texas law forbade illegal immigrants to attend public schools, and the court came in and said, no, you can't do that. Just because they're illegal immigrants, just because they're non-citizens, doesn't mean that they are not protected under the Equal Protection Clause. In fact, they're under this jurisdiction, and so you cannot have a law which forbids them to attend public school. Prop 187, you may remember some years later in California, California tried to overturn this and say that we are going to enact a law that says that, or a proposition in this case, which would become law, which says that if you are undocumented, you cannot avail of these particular services. But the court actually used the Plyler decision from 1982 to say we have federal law here, we have a federal decision which is going to preempt the California decision, and Prop 187 cannot stand.